Good morning, everyone. I hope everyone's doing
Morning.
Good morning, Your Honor.
good morning. Mr. White, good to see you.
Good seeing you, Your Honor.
I guess we'll get started when the jail comes on.
A couple of mental health evaluation forms that we sign. Please. Let me get a chance. That needs to be signed. Friday calendar, Thursday calendar. And then this one.
Good morning, Your Honor.
Good morning, Ms. Tortorello. Hope you're doing well.
Hope you're doing well too, Your Honor. Who is the litigation manager today?
Ms. Lewis.
Miss
I'm logging on now.
Yeah, she's logging on in.
Okay, I'm gonna go ahead and send her a felony transfer order.
For what position?
37.
Can I get that one already? What's the name on it?
Shakara, I believe it's Shakara White Walker.
So for the guy from Mr. McLeod, either just a minute to just time server, he has already served, we've been there for 18, well, it's more than 18 days now, but at the time when I did the count, it was 18. But they can hash it out. I can't always cover up those situations. I keep telling folks, could estimate what you think the jail's gonna do. Instead of time served, you have to do all that credit for this and that. Just say time served for the time they've been in here. Could say 12 months to serve. 16-day credit time for 8-day, they double it up.
Well, that's the way we've always done it.
I know, and it was, but it may apply to the charge that they are, but if they try to do these global police, just like the circumstance with there.
No, I understand that. But I
Yeah.
think that's why it was done like that.
Yeah.
because Good morning, Ms. McLeod. How are you?
I'm fine, thank you, Judge. How are you?
Good. I see that you have a case that's on the add-on calendar, the jail status calendar with Mr. Finnick, who I believe that we dealt with last week or sometime previous, and there was an
Yes,
issue
Your
with
Honor.
him remaining in jail. Who is the solicitor on this matter?
Your Honor, that would be me.
So it's my understanding that for Mr. Finnick, who is 22 CR 001578J and 22 CR 006681J, that there was supposed to be a resolution, a global resolution of time served. And because of how it was written, I believe the jail is keeping him in. So, Ms. Tortorello?
Yes, Your Honor. So the case at issues is battery family violence case, 22 CR 006681J. The state already has conveyed the offer to Attorney McLeod. The offer is 12 months served 44 days, credit for time served 22 days, balance suspended, no further contact with the victim, family violence intervention program, no drugs or alcohol, no weapons.
Okay, have we already taken care of this case or not?
Yes, Your Honor.
Yes, Your Honor.
It was already before the SAP calendar last week. I think it was October 20th. And ASG King handled the matter.
October
Okay,
18th.
so the pleas have already been conducted, right?
That is correct, Your Honor,
It's
but
just
there
the
was a
issue.
misunderstanding and the jail kept him.
Okay, so what do we need to do? Just make this one time served?
It would be balance probated, Your Honor. So we're giving him credit for time served so he can get out of
Okay.
jail and start his probation.
All right, so how would you all like it? Tell me again how you'd like it worded, Ms. Tortorella.
12
12
months,
months to serve,
44 days,
44 days,
credit for time served, 22 days,
22 days. All right.
balance probated.
Right, with the conditions. Is that your understanding, Ms. McLeod?
Yes, Your Honor.
Okay, so can we just go ahead and make those changes? Is he necessary this morning?
He's not necessary, Your Honor, because he's actually ready to go home.
Okay, so we'll just make those changes and get those, since everybody agrees on it. And then it was basically a clerical or just a mistake that the jail has a way of doing things. So we will make that change, and then we won't need Mr. Finnick this morning, okay?
Thank you, Your Honor.
Yes, Your Honor.
All right.
Oh, may I interject, Your Honor?
Of course. Good morning, Mr. McLean.
Good morning. While Ms. McLeod's on the screen, there is an add-on number 2 where Odyssey had some funny stuff. It had Aaliyah Harmon listed as the defense lawyer, but it also said conflict attorney needed Maureen McLeod. That's Mr. Ja'Cory Vaughn.
That's correct. He's my client.
Okay, I just want to make sure you knew about that being on the
Oh,
calendar.
absolutely. That's one of the reasons.
Very good.
I filed a motion for the modification.
Okay, you've got it. There was just the amusing mistake, and everybody's straight. Thank you.
Yeah, I put that on.
Okay, let's put it- I didn't realize. Mr. Jordan and Ms. Grace, are you there?
Yes, Judge, I'm here having difficulty.
Good morning.
Good morning.
Have you, oh, there we go. They're on now. Thank you.
It's a minute. Since she, one we just did.
Ms. Grace, this is your first time hosting, is that right?
Yes, in training, I did it last week. Yes, Judge.
All right, so you all know that Ms. Grace is training today, so don't go so hard on her.
Thank you, Judge.
Everything's signed.
Thank you, Judge. You said it's in the sheet.
Ready when you are, Norris.
Good morning, Your Honor.
Good morning, how you doing?
I could have been doing better.
Okay, let me know when you're ready.
Okay, we're gonna bring up, the first one is gonna be Mr. Cortez Harvey. I don't have positions with me right now, Your Honor.
Okay, what's the last name?
Harvey,
Harvey, okay. Mr. Harvey's position, number 16. So Mr. White, this is just going to be an arraignment.
Your Honor, I believe that's Mr. McLean's.
Oh, I'm sorry,
Mr.
Mr.
McLean
McLean.
He can send his announcements.
Yes, I'm clicking around, unmuting there. It is number 16, Your Honor, and the announcement is for Mr. Harvey, not guilty. Bond is moot at this time.
Okay, so it's going to be an arraignment this morning, correct?
Correct.
Okay, good morning, Mr. Harvey. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Harvey, you've been charged in case 22 CR 006786A with possession of a pistol or revolver by a person under 18 years of age, simple battery against a police officer, corrections officer, or detention officer. Each one of these charges carries a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do.
How do you plead, Mr. Harvey? Guilty or not guilty? We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, Mr. Harvey.
Yes, sir. Yes, sir.
Thank you.
Good morning, Ms. Bacchus. How are you today?
Good morning, Your Honor. How are you?
You're always so perky. Good to see you.
Oh, wonderful. Thank you so much.
Your Honor, we done with Mr. Harvey? I'm sorry.
No, yes, we're done. Thank you.
Okay, you go sit down. Next, we have Isaiah Ford. I don't have the position number with me, Your Honor.
Was that Porter?
No, Ford, number 12.
Ford, okay, thank you. And this is a negotiated plea.
It is.
Good morning, Mr. Ford. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down, sir. Thank you. Ms. Bacchus?
Yes, Your Honor. The offer on this case is 12 months to serve 16 days, credit for time served 16 days, balance suspended, and stay away from the incident location, which is the Publix located at 2020 Howell Mill Road. Nothing further.
Mr. McLean?
Your Honor, the defendant asked the court to accept his negotiated plea of guilty.
Mr. Ford, it's my understanding that in case 22 CR 006842Y, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
I understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury.
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Ford. You know you can't go back to that Publix, right?
Yes, sir.
All right, good luck to you, sir.
Your Honor, I just asked that the defense would stipulate to the factual basis menu and ID on the record.
We do so stipulate.
Thank you.
Next, Your Honor, we have Mr. Demetrius Holt.
That's position number 17, Mr. Holt.
Your Honor,
I need to speak.
Yes.
Hold on, Mr. Holt. Your Honor, I represent Mr. Holt. My expectation is we're going to enter into a negotiated plea today. I did want to see if I could have a quick word with the prosecutor handling the case before we do that.
I need to speak also, sir, to, it was a mix up yesterday. When I talked to my attorney, Mr. Tom, I had 2 more lawyers come to see me. I got three misdemeanor cases. There are 3 different lawyers came to see me yesterday on 3 different cases.
Okay, all right. Good morning, Mr. Holt. Hold on for us for a moment.
And I thought,
Okay, we're gonna address you, sir. So you'll have an opportunity to talk to your lawyer regarding this. Okay, so just hold on for me. You can put your hand down. All right, so we're gonna get with you. So would you like to speak with the prosecutor first, and then you can call your client? How would you like to handle it?
Yes, Judge. I guess he may have some concerns that I need to make sure he's still on the same page. But if I could speak to the prosecutor briefly, that would be helpful.
Would you like to go into a break? Is this your case, Ms. Bacchus?
It is, Your Honor.
Can we go into a breakout room? It's Mr. Owen and Ms. Bacchus, and then after you come back out, we'll have you call courtroom 2 to speak to your client.
And Mr. Owens, you can call extension 404-612-2392. He's gonna be sitting in the chair waiting for your phone call.
2392. Thank you, sir.
That's correct, yeah. Hey, Your Honor, can I say one thing? Sit down.
Yes.
I see what I'm trying to explain.
Oh, no, Mr. Holt, no, I don't, you have a right to remain silent. Anything you say can be used against you. So listen, I'm gonna let you talk to your lawyer, and then if you want to talk to me and you discuss it with him, I'm happy to listen to you, okay? But let's talk to your lawyer before you talk to me, okay?
Yes, sir.
All right, and I tell you, I'll listen to you,
I
okay?
have 3 different lawyers that are trying to tell you.
Okay, so we're gonna get it straight. All right. So while they're gone, we're gonna need some of Ms. Tortorello's case, because Ms. Bacchus is not going to be here.
I'm 1 through 19, Your Honor, and add on 1 and 2, and so she has all the other cases.
1 through 19.
Your Honor, like I said, I don't have a calendar with me right now. So I'm pretty much trying to wing it.
Okay, that's fine. Just tell me who you have next, and I'll see.
Next one is Mike Centel. Is that you, Ms. Bacchus?
I don't believe so.
Centel.
How do you spell that last?
That's 31 SAINTIL. Mike.
That would be ASG Tortorello, I believe.
Okay, so this is good. Thank you.
Your Honor, who has, good morning, this is the South Annex.
Good morning.
Does Ms. Bacchus have position 37, Ms. Walker?
No, that's
Go ahead.
That's my case.
Okay, she's here, and we have the probation revocation. Position 1, Ms. Jenkins here also, here at the South Annex.
Okay, thank you.
Deputy,
Good
Miss Walker is a felony transfer. And I already sent the order over to Your Honor.
Yes, I have it here and I've signed it, so we don't need Ms. Walker this morning. Oh, no,
Oh,
I
you-
guess, no, we're still gonna have to set a bond.
She's right here. Sit down, Ms. Walker.
Okay, but we're in courtroom 2 right now, unless courtroom 2 wants me to go to the South Annex.
They don't mind, Your Honor.
Okay,
Hey, Milton,
So,
I'm
Judge-
by myself today. I'm by myself. I don't have Francois with me.
all right, so, Officer Melton, I'm gonna go back to courtroom 2 since since Mr. Santel was here first. I'll come back to you.
Not a problem, Your Honor.
All right, Mr. White, this is a no-low plea.
It is, Your Honor.
Can we be put into this breakout before you all start? Just,
Right, and as we know, we have a trainee today, so.
okay, it's
I
fine.
was just trying to ask, are they still going in the breakout? I'm ready to put them in. That's Bacchus and Owens.
And
That's correct.
ASG Walker,
Okay, thank you.
no problem.
All right. Mr. Santel, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. Thank you, sir. Ms. Tortorello?
Yes, Your Honor, the state's offer is time served, 15 days. Your Honor, and the state's not objecting to the no-low plea.
Okay, Ms. White,
Your Honor, that's what we negotiated. We ask you to accept that please negotiated.
Ms. Tortorella, anything further?
Yes, if defense could please stipulate to the facts, venue, and ID of the matter.
We can have a standing stipulation of fact.
It broke up, Your Honor.
Mr. White, I believe, said that he's going to have a standing stipulation to the fact with all the cases that are going to be entering pleas today.
Okay, thank you.
I'm sorry, Ms. Tortorella, anything further?
No, nothing further.
Mr. Santillo, it's my understanding that in case 17 CR 015771E, you wish to plead no to suspended or revoked license. Is that correct?
Correct, sir.
Are you under the influence of any drugs or alcohol this morning?
Yes, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading no to it, you're giving up the right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead no?
Yes, sir.
I'll accept the no plea, Mr. Santillo. Good luck to you, sir.
Thank you, Your Honor.
All right, where do you want me to go next?
Next, Your Honor, you got position number 29, Mr. Pringle.
I like to speak to my attorney too also. Good morning, Judge.
Yes, good morning. So,
Judge, this is just a waiver.
yes, do you want to, he's asking to speak with you?
I can speak with him. I'm not sure what we can accomplish, but absolutely.
Yeah. Hey, Tom, you could call at 2392 extension 22.
Okay,
Yeah,
got it. Calling right now.
okay.
All right, let's see.
I guess you can go to South Annex.
Okay, who do we have? Officer Milton, who do we have?
You can do position, Ms. Walker, position 37.
Okay, I believe that Ms. Walker is Mr. Ford's case. I mean, Mr. White's case.
Okay, we can do the probation revocation. Switch seats, please. Ms. Jenkins, number 1 on the probation revocation calendar.
Okay.
This will be rather brief.
Okay. Let's see. Good morning, Ms. Jenkins. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Good morning, Ms. Allen.
Good morning, Your Honor.
Now you can proceed.
Ms. Jenkins was sentenced to probation on June 15, 2018 for the charge of no insurance and no driver's license. She was required to report to probation, pay a fine of $551. As of today, the defendant has failed to report to probation. She has failed to pay that fine in full. It's 1 month, 14 days remaining on her case. At this time, probation recommends that this case be time served.
You don't have any objection to that, Mr. McLean?
It's a great recommendation. I would point out, if the court wishes to go a slightly different direction, when I interviewed her, she said, I had one non-reporting probation once upon a time, and I had a reporting probation once upon a time, and I sure did think this was non-reporting. I didn't mean to skip. So if the court would consider perhaps not holding her in revocation, not holding her in violation, that would be super too, but the recommendation is not bad.
And also, Your Honor, I just want to put on record that she missed her court date. So that is why the warrant was submitted to the judge for her arrest, because she missed her court date. It wasn't necessary about failure to report to probation. We tried to get her, to at least report to court, to talk to the court about it.
Okay, thank you. And was there a fine associated with this?
Yes, Your Honor. The judge gave her an option. She was required to pay $551 or do 40 community service hours.
Well, she
Okay.
probably should have, right, probably, yeah, we don't have an explanation for that, Your Honor.
Wow. So I'll do one or two things, Mr. McLean. If she wants to go back on probation for a month and a half to do the 40 hours of community service, I'll let her do that. If she wants to have time served and be done with it, I'll let her do that. What does she want to do?
I think the time served sounds good at this point.
I thought you would. All right. Ms. Jenkins, good luck to you, ma'am.
Thank you.
And Mr. McLean, I sent that information over to you. I updated the petition, so you can send that petition, the signed petition, over to our office.
Okay,
Okay?
all right, I'll get that.
Your Honor,
right
that
after court.
concludes my business. May I be excused?
Yes, have a good day. Thank you.
Thank you.
South Annex, is that all? You've got one more this morning, right?
Yes, Your Honor, move on to the
Okay, I don't believe Mr. White has had an opportunity. I believe this is, if I'm not mistaken, Mr. White, this is Ms. Walker, position 37. You did not have an opportunity to interview her.
I mean, that's correct, Judge, but the state is transferring that to felony division anyway.
Okay, I'm gonna have to set a bond though for her this morning. So if you want to consult with her before I set a bond, I'm happy to let you do that.
Okay, so the bond that she has in place,
Is there a bond in place already?
there should be, 1 second.
There is
Okay.
$2,500.
And
That's
that's a
correct.
good bond?
Yeah, through surety.
Okay, so you want it to remain at a good bond, Mr. White?
Well, I mean, let me speak with her if I could.
Okay, I thought you might want to. All right, so can we have South Annex, Mr. White caller?
Yes, 37122.
Do the guy on 5 South End from Plains?
Okay. So let's see, who do we have in courtroom 2? Or,
Your Honor, this is Mr. Pringle again.
okay, and we'll have to wait for Mr. White to get back then, right?
He was just on there.
Yeah, he's gone to talk with another client at the South Annex. Apparently, there are a number of people that they were not able to interview, so it's gonna take us a bit longer this morning because I'm gonna have to talk to the people.
Yeah.
Anyone we can go to?
Well, you can go to 5 South. I believe that's McLean's.
Okay, who do we have at 5 South?
Position number 8.
Okay.
Cochran.
And this is just gonna be an arraignment, right, Mr. McLean?
Correct.
All right. Good morning, Mr. Cochran. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Thank you. Mr. Cochran, you've been charged in case 22 CR 006949A with simple assault and criminal trespass. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do.
How do you plead, Mr. Cochran? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, Mr. Cochran.
Thank you.
Can I speak to Mr. McCain?
I
Mr.
will
McLean,
be at the jail later this afternoon and can put you on my list if you'd like.
Yes, sir.
Okay, I'll come see you.
all right, let's see. Mr. White's not back. Is there anyone else that we can?
Your Honor, is there an attorney Hamford in the courtroom for Mr. Giles, who's position number 13?
He's in our courtroom right now.
Yes, sir.
Okay, can we bring Mr. Giles up, please? I'll bring Mr. Giles up.
Okay,
Come on.
you ready, attorney?
It's gonna be position number 13, Mr. John Giles.
We're ready for you, counsel.
So you say my.
I'm sorry. You're fine, just over here at the podium. Tell me your name.
Attorney Render here, Your Honor, on behalf of Mr. Giles.
Okay, for the court reporter, can you spell the last name?
My last name is Render, Judge.
Okay. Mr. Render, what are we gonna do with Mr. Giles today?
Your Honor, I'm asking for a modification on the bond, a slight modification. Right now, I believe he has a cash bond only. We're asking for the slight modification for a property/surety bond.
Okay, let me get those bonds. Good morning, Mr. Giles. I'm Judge Eric Morrow. This is the state all-purpose calendar. We're conducting this calendar today by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Do you have those bonds?
This is an FTA through Judge Edie. That he failed to appear.
So he's already been arraigned?
It doesn't look like it. He was on a plea arraignment on June the 15th of 21. And then he FTA on September 21st of 21. And then another FTA.
So I need to
bench warrant
arrange
on
him.
the 22nd of 22, yeah.
Okay, Mr. Render, your client hasn't been arraigned yet, so as such, I'm gonna go ahead and arraign him this morning. I take it that he's gonna be entering a not guilty plea, is that correct?
Yes, Your Honor.
All right, Mr. Giles, you have been charged in case 20 CR 004999Y with simple battery, family violence, and simple battery. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. Render?
I do so waive.
How do you plead, Mr. Giles, guilty or not guilty?
Not guilty.
We will record your not guilty plea and your case will be returned to the division judge. And you'll get notification of your next hearing date. Mr. Render, the way that I normally work in this court is that if you need a bond modification that I have set or that was set at the SAP calendar, I will address those type of bonds. If the case was because someone did not show up for court and another judge, a division judge sets that bond, I have you go back to, and in this case, Judge Edie. I'll have you go back to Judge Edie for him to modify the bond that he set, okay?
Understood. So follow up bond motion with Judge Edie's court.
Exactly.
Understood, Judge. Thank you. Nice to meet you, Judge.
Okay, have a good day.
It should be on virtually.
Can I address the court?
Mr. Giles, you have a right to remain silent. Anything you say can be used against you. I would suggest that you talk to your attorney in this matter and he will speak with you to answer any questions.
Mr. Giles, unfortunately, the judge cannot amend the bond because you're in front of Judge Edie. So there's nothing we can do at this time, Mr. Giles. I'll immediately file for you, Mr. Giles, okay?
I have full custody of my daughter and I've been arrested for 17, 18 days now. I don't know what my daughter is. And this case is a case from 2020. If you can see on file that when y'all sent the court date, it was sent back to you guys. I really can't spare no more time to sit in jail because I need to get to my daughter. I don't really understand what's going on right now. Like my lawyer, I told my lawyer that if we can, whatever we can do to get this resolved right now, I'm willing to do it because this is the case from 2020. Like, I don't even have to, it ain't even got to be a bond or whatever, but I need to get back to my daughter. I have full legal custody of my daughter through the Fulton County Courts. And I've been sitting in jail just waiting. And now I'm gonna have to wait some more and I need to get back to my daughter. This case is an old case and I'm ready to resolve the case.
I understand. And Mr. Giles, let me just say that the case would not get resolved today regardless, because they're asking for 90 days of jail time for a guilty plea in this matter. So, you know, even if you pled guilty, you would not be getting out of custody today. What I recommend is that your counsel is going to file his motion for modification in front of Judge Edie as soon as he possibly can be heard by that judge, sir. All right.
Your Honor, I do want to let Attorney Render know, according to what I have in Odyssey, it's not a cash bond, it's a surety bond that he has. Maybe I have the wrong information, but that's what I see. It's a $5,000 surety bond.
No, it's a cash bond. That was the first bond that he made with Freedom Brain at the time. It's a cash bond.
Was there a bond forfeiture?
Yes, it was.
Okay, all right, thank you.
And Your Honor, may I ask if the state would consent to a modification to surety bond?
Oh, I think that has to be handled in front of Judge Edie per the judge's ruling, so.
Well, no, if you consent, Ms. Bacchus.
Well, that's gonna defer to ASG Walker.
I have to turn my camera on. Good morning, Your Honor.
Oh.
And that the state will not be consenting. Good morning, Attorney Render.
Good morning, Mr. Walker.
All right. Wonder why I knew that that's what Mr. Walker was going to say.
Understood, Judge. I wanted to just try for my client, but I'll go visit Mr. Giles and I'll ask him my test, take the next step. Thank you, Judge.
All right, very good. Have a good day.
You as well.
Who do we have next?
Your Honor, can we go back to position number 17, Mr. Demetrius Holt?
Okay. Did we work that out?
Yes, Your Honor. After discussion with the state, we do intend to accept the offer from the state and the negotiated plea today for Mr. Holt.
Okay. Good morning again, Mr. Holt. Let me just start from the top. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Thank you. Ms. Bacchus.
Yes, Your Honor. The state's offer on this case is going to be 12 months, serve 16 days, credit for time served 16 days, balance probated, a theft class, and stay away from the incident location, which is the Publix at 1001 Ponce de Leon Avenue.
Any objection to termination once he completes the theft class?
I suppose not, Your Honor. Based on the felony holds that he has, he's probably going to get out and have limited time anyway, so that's no problem.
All right. Owen? Counsel?
So that was the offer that was relayed to us, and that was relayed to Mr. Holt. He does wish to accept that. He understands. Well, yes, Your Honor.
Okay. Anything further?
Nothing, Your Honor. Just as she mentioned, he may not be released to probation immediately because he does have some felony holds. So I just wanted the court to be aware of that. But other than that, I've gone through everything. One thing I want to ask is, is there any plea paperwork that I need to fill out for this?
I will send it over to you. Yes, sir.
Thank you so much. So at this time, I don't have anything further to offer on Mr. Holt's behalf.
Okay. Mr. Holt, it's my understanding that in case 22 CR 006835C, you wish to plead guilty to theft by shoplifting. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you've given up your right to a trial by jury.
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
And I'll accept the plea as negotiated, Mr. Holtz. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the theft class, then the probation is going to terminate. So the sooner you get that done, the sooner you won't be on probation for this case. Okay.
Yes, sir. Can I speak one thing?
Again, you have a right to remain silent. Does it have something to do with a procedural matter? I don't want you to say anything about the case.
It's not about the case.
Okay.
It's just, I just want to make a statement to your court, sir. Thank you, but I want to make a statement to your court that upon my felony case, Eric Choate is my attorney. I've been trying to get in touch with him. I'm trying to enter into a program for drug and alcohol. I want to bypass the indictment. Can anyone in your courtroom get in touch with Mr. Choate and let him know sometime that I really need to talk to him about bypass my indictment and get into a drug and alcohol program because I need help, sir.
Okay, I understand. So, counsel, can you do that for your client? Can you,
So, yeah, as I mentioned to Mr. Holt, I did try to reach out to his attorney, and I will continue to try to reach out to that attorney. I left a message for him, but I will make another attempt.
Okay, we'll do our best, Mr. Holt. All right, good luck to you, sir.
Thank you, sir.
You're welcome.
Next, Your Honor, we have position number 3, Mr. Christopher Bell.
Okay, Mr. McLean, have you had an opportunity to, I see that you have, this is a time.
Right.
It's a time to
Yes.
really work this out.
I have not yet asked the state if that slight variation, slight is our term, was acceptable.
Well, I have down that the office time served, and that was your question, right?
Well, they want an ADET, and his point has to do with he's in the jail anyway, and can he get the ADET done in the jail? And I was thinking, I think he's going to be stuck in the jail for a bit, for a while.
Well, if so, then when he gets out, he'll be on probation for this, and he can get the ADET at that point in time.
Right. So
I mean, his probation won't start till he gets out of jail.
that's true. That is absolutely true.
All
Mr. Bell,
Yes.
do you understand the judge's point about your need to get that evaluation will not even start until you're free?
I'm not understanding what are we saying?
The state is requesting that you have an alcohol or drug evaluation and treatment if necessary. So that's going to be part of the sentence. So once you get out of custody, then you'd have to do the alcohol drug evaluation and treatment if necessary. And if you don't need any treatment, then that's going to be the end of it. The probation is going to terminate. If you do need treatment, you'll get whatever help you need. And then once you complete that treatment, then that'll be the end of the probation. So, so that's where we stand at the present time. Is that right, Ms. Bacchus?
That is correct, Your Honor.
Okay, so you understand, Mr. Bell?
So you saying I need a drug treatment program?
No.
Not necessarily.
What I'm saying is that you're going to be evaluated as to whether you need treatment for alcohol and drugs. If you don't need treatment, then the evaluation will say you don't need treatment and you'll be done.
Okay.
Okay?
Yes.
You understand?
Yes.
Okay.
So I think that just turned it into a negotiated plea, Your Honor.
All right, very good. Good morning, Mr. Bell. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. Thank you, Mr. Bell. Ms. Bacchus?
Yes, Your Honor. On count 1, the offer is time served. So that's going to be 12 months, served 9 days, credit for time served 9 days, balance suspended. On count 2, it's going to be 12 months, served 9 days, credit for time served 9 days, balance probated, the ADET, and termination upon completion.
Mr. McLean?
I believe that probably is my client's understanding of the negotiated plea. Is that correct, Mr. Bell? Is that what you want to do?
Yes, sir.
Okay. We'd ask the court to accept the negotiated plea.
And I ask that the defense would stipulate to the factual basis, venue, and ID.
We do so stipulate.
Thank you.
Mr. Bell, it's my understanding that in case 19 CR 009299Y, you wish to plead guilty to willful obstruction of a law enforcement officer and public drunk. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir, and I thank you guys this morning.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea as negotiated, Mr. Bell. I am going to waive the probation fees once you get out on probation to help you get and stay on your feet. And as soon as you complete the ADET, then the probation is going to terminate, okay?
Yes, sir.
All right, good luck to you, Mr. Bell.
Yes, thank you.
You're welcome.
Thank you, Your Honor.
Your Honor, I don't know if Mr. Tom is available, but I think I have the bottom half of the calendar.
Okay, yeah, I think Mr. White's with us.
Okay. Okay. So can we go back to Mr. Pringle?
Okay.
And Judge, I've spoken to Mr. Pringle. We just going to go forward with the waiver, or I'm sorry, arraignment.
Okay. Good morning, Mr. Pringle. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Good morning, Judge.
Morning. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, you can put your hand down, Mr. Pringle. You've been charged in case 22 CR 006837J with battery, family violence, and willful obstruction of a law enforcement officer. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you pay formal reading of the accusation, Mr. White?
Yes, Your Honor.
How do you plead, Mr. Pringle? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Good luck, Mr. Pringle.
Your Honor, what position was Mr. Pringle?
29.
Okay, thank you.
Next, we have position number 38, Kevin Warfield.
This is going to be an arraignment and a bond hearing.
I guess, Judge, I'm not sure how you want to handle it. But I believe he's been arraigned, probably when he was at division.
Okay, so he missed a court date.
That's correct, Judge. I'm not sure, that may have been a plea arraignment that he missed. I mean, it was almost 2 years after his arrest, so.
Counselor, is he not in the state prison in Newton County?
No, he's right
He's
here.
been transferred here for the case. I was just wondering if he's still, because he has a hold.
He does have a hold,
out in
but
Newton.
it shouldn't affect this, because I mean, he was incarcerated at the time of his court date that he missed. So
Okay, so if he was incarcerated, then he couldn't make it because of the incarceration. So
he was in DeKalb County at the time. He was over there for 5 months. I saw a certificate of incarceration
Okay.
from May 22nd to October 17th of this year.
All right, so if that's the case, then Ms. Tortorella, you don't have any objection to us reinstating the initial bond, do you?
I think he already has the initial bond. It's a surety bond. And he has a hold out of Newton.
The bond was revoked because he missed court, so it needs to be reinstated.
Right. So we're gonna do that so that he can go ahead and take care of what he needs to take care of, and is it the cab or wherever he needs to
But
go?
he's never been arraigned, Judge. He was told him because he was in custody.
Okay, Mr. White, I'm being told that he wasn't arraigned.
That's fine, Judge. We can arraign him here.
Okay. Mr. Warfield, can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
All right. Mr. Warfield, you were charged in case 21 CR 002363D with speeding, possession of an open alcohol container, failure to obey traffic signs, signals, and markings, and driving under the influence of alcohol less safe. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. White?
We do, Judge.
How do you plead to these charges, Mr. Warfield? Guilty or not guilty? We will record your not guilty plea. The case will be returned to the division judge, and you'll get notification of your next hearing date. Mr. White will reinstate the original bond that was in place, given that your client missed court because he was in custody.
And just to put on the record, Your Honor, jail screen shows he has a $6,000 surety bond for all his charges.
That's because he missed court.
Yeah, but he has a bond.
Surety is not responsible for no more. There's no surety on here at all.
Okay, well, apparently why don't we do this? Apparently there's no surety on here. Mr. White, what I'd like to do is just convert whatever bond there was. Do you know what the surety bond was?
Please.
Are you,
I'm
Judge, are you?
gonna convert it to a signature bond,
Thank you, Judge.
okay? So if you could prepare that for me and get it to us, making whatever the terms were in that bond, and just make it a signature bond, okay?
So that'll be a $6,000 signature bond, basically is what we're going to say.
Yes.
Okay, thank you. I'll get that to you as soon as we're done.
Okay, very
And
good.
that, Your Honor, that he be placed back, go to his Newton County. He has a hold there.
Okay, yes, I'm sure they'll transfer him where he needs to go.
If that can be placed on the bond, Your Honor, this case is I think it's an old DUI case, Your Honor, and it hasn't been resolved still.
Okay, well, I'm not gonna put that on the bond. I'm just gonna let them do what they need to do with him. So if they want to take him to Newton County, they can. If they don't, then, you know.
That'll be.
And, okay.
All right. All right, good luck to you, Mr. Warfield.
Position number 35, 4 South.
Um, 35, is this Thomas?
Yes, it is.
Okay. And this is also going to be a arraignment in the bond hearing.
That's correct, Judge.
Good morning, Mr. Thomas. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Mr. Thomas, you've been charged in case 22 CR 0067788H with criminal trespass. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. White?
Yes, Judge.
How do you plead, Mr. Thomas, guilty or not guilty?
Guilty.
I believe you were going to enter a not guilty plea. Is that not correct, Mr. Thomas?
Not guilty, yes, sir.
We'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Do we have a bond for Mr. Thomas?
He does have a bond set, Judge, it's $1,000 surety.
Okay. Let's see. I saw Mr. Thomas back on October 10th and gave him a $1,000 surety bond to stay away from the Georgia Tech campus. From what I can recall, there was issues with him having a number of incidences at Georgia State. Is that right, Ms. Tortorello?
To my understanding, yes, Your Honor. He also, are we going to start bond argument, Your Honor, or?
Yeah, you go ahead.
Okay, so the state's asking for that $1,000 surety bond to remain the same with the same conditions. This defendant does pose a flight risk and a risk of reoffending and committing felonies while he's out on bond. He's currently wanted out. He has an outstanding warrant out of Lake County Sheriff's Office out of Crown Point, Indiana. There's no hold. He's just wanted for failure to appear. Shows flight risk, Your Honor. This incident occurred this month, October 8th, 2022 at Georgia Tech in Atlanta. Georgia Tech Police Department responded to the call involving a suspicious person, later identified as the defendant, Daryl Thomas. Upon arrival, an officer Claiborne was already speaking to the defendant. Police searched the defendant's name in the system, which came back the defendant had an active criminal trespass warning expiring August 18th, 2024 from Georgia Tech. That case number is 2022067243. The defendant was issued this warning back in August 18th of 2022 by Georgia Tech Police. These events did occur in Fulton County, Georgia. Your Honor, he has 9 cycles here in this state. He's a convicted felon, 1 cycle out of Indiana, 6 cycles out of Illinois. For that reason, Your Honor, we are asking for that $1,000 surety to remain as set. Nothing further.
All right.
Judge, yes, we're asking Mr. Thomas be allowed to sign his own bond. He's already been in jail 18 days at this point on a criminal trespass. As you heard, there is another hold at Lake County. We'd ask that he be allowed to sign his own bond so that he can go to that hold and then come back at a later date to address these issues. As far as the Georgia Tech criminal trespass is concerned, when he was in the criminal trespass, he says that he was told by one officer that there were certain areas of Georgia Tech that he would be able to access, I guess, for public that are generally accessible to the public. Georgia Tech, as you know, they have sort of a vast area that they're allowed to cover. So he didn't understand that he had violated the trespass warning. I've explained to him that the easiest thing for him to do is just not go anywhere near Georgia Tech from now on. And he says that he can do that. He has been employed at McDonald's for 7 months and he's a resident in Dalton, Georgia. So we're asking to convert this based on the fact that it's a criminal trespass. He has already been in 18 days at this point. He's not going to be released anyway. Let some other county pay to hold him in jail and he can come back at a later date.
Does he have stable housing, Mr. White?
He does, Judge.
All right.
And Your Honor, just to correct the record, he doesn't have an active hold. He does have a warrant for an FDA out of Indiana. There's no hold at all for this defendant.
Okay. I'm not going to keep him in any longer on a criminal trespass, so I'm going to convert the good bond to a signature bond. Mr. White, he's on the bond that was initially set. He's to stay away from 190 5th Street Northwest, which says Georgia Tech campus. So if he even believe, Mr. Thomas, if you even believe that it could be part of Georgia Tech, you need to stay away from it, okay? All right, good luck to you, Mr. Thomas.
Thank you, Judge.
Who's next?
Excuse me, Judge, how much was the bond amount?
$1,000 signature.
Okay.
Position 37, Ms. Walker.
Okay. This was transferred. There's already a $2,500 good bond. Ms. Tortorella, is this your case?
Yes, Your Honor.
You can proceed with the argument.
Yes, Your Honor. Just to add, this is a felony case and therefore this jurisdiction does not have the authority to hear bond hearing. That's part of my argument. It's been already transferred to Superior Court because this is a felony. Your Honor, we're asking for that $2,500 surety bond to remain the same with the same conditions. This incident occurred on October 7th, 2022 at Walmart in Union City. An Officer B. Walker of the Union City Police Department was dispatched to the incident location in response to shoplifting. Upon arrival, the officer made contact with loss prevention. Officer Bentley, who said the defendant Jermaine Moore and co-defendant Shakara Walker selected multiple food items and began to conceal them in grocery bags. Those items totaled $120.77. Both parties passed all points of sale without paying for the items, and defendant was arrested, and all these events occurred in Fulton County, Georgia. To add, Your Honor, this defendant has theft by shoplifting convictions, one on January 13th, 2020 out of Chamblee Municipal Court, one out of Riverdale Municipal Court on February 23rd, 2020. May 17th, 2022, she pled guilty to theft by shoplifting in Fulton County State Court. That's 21 CR 002-782E. On May 17th, 2022, she again pled guilty to theft by shoplifting out of Fulton State Court, 21 CR 005491E. Therefore, she poses the risk of reoffending, Your Honor, while she's out on bond, and a risk of committing felonies, Your Honor. And for that reason, we are asking for that $2,500 surety to remain set. Nothing further.
Mr. White?
Your Honor, Ms. Walker has no income. She's already been in jail since the 7th. This is $120 worth of food items. It's not like she was going to Saks and, stealing luxury items. She's trying to feed her family. She has 5 children ranging in ages from 3 to 11. They are currently with her elderly mother, and she needs to get out of jail in order to help take care of her children. We understand that she does have a few convictions for, these are all misdemeanor convictions. The only reason this is a felony is for recidivist nature of the statute. So we're asking that she be allowed to sign her own bond. She cannot make any bond. And again, she's already been in jail 19 days at this point for stealing $120 worth of food.
Okay. Given that she already has a bond and it's been transferred, I'm going to let the Superior Court deal with it. I'm going to leave the bond where it is for now, and if there's to be a modification, I'll let that happen in Superior Court. Good luck to you, Ms. Walker. What do we have next?
Can we go to the add-on calendar, position number 2, Mr. Ja'Cory Vaughn?
All right, who represents Mr. Vaughn?
I do, Your Honor.
All right.
I do.
And, okay. Good morning, Mr. Vaughn. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree?
Yes, Mr. Livingston.
Case heard by video. Mr. Vaughn?
Yes, sir.
Thank you. Ms. McLeod, what are we doing with Mr. Vaughn today?
Your Honor, I filed a motion to modify his bond, Your Honor. He has a $10,000 cash bond, Your Honor. He's in no position to make that bond. So essentially he'll be sitting in jail until his case gets heard.
Okay, may I see that bond, please? So he needs to be arraigned also, is that correct, Ms. McLeod?
Yes, Your Honor.
All right. Mr. Vaughn, you've been charged in case 22 CR 006711E with cruelty to children in the 3rd degree, battery, family violence, and obstructing or hindering persons making an emergency telephone call. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you wait for a reading of the accusation, Ms. McLeod?
I do, Your Honor, and he enters a plea of not guilty.
Okay, and how do you plead, Mr. Vaughn, guilty or not guilty? Mr. Vaughn?
Not guilty.
Okay, we'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Ms. Harrison, good morning.
Good morning, Judge.
Can I get Mr. Vaughn's history, please?
Yes. 7 cycles. Last arrest was May of this year for battery, family violence in Fulton County. Record indicates an open case pending for theft by taking, battery, family violence, cruelty to children, 21 CP 202806. An additional open case for battery family violence, case 22CR002814E. No disposition listed on that arrest. Nothing further, Judge.
All right, Ms. Bacchus? If you're talking to me, you're on mute.
My apologies. This incident occurred on the 5th of October. An officer was dispatched to Van Diver and Enon Road Southwest in reference to a man hitting a woman. Officers arrived on the scene and made contact with the victim, Alexis Johnson, who stated that her boyfriend, who's the defendant, was beating her and stopped her from calling the police. Ms. Johnson stated she picked up the defendant from work and she had gotten him something to drink. He said he was hot. That somehow turned into an argument. She said the defendant became irate, began saying vulgar things to her while the children were inside of the car. He began to kick the dashboard, so she pulled over to call the police. She said she was afraid for her and her children's life. She said that the defendant tried to take the phone from her as she tried calling the police and began to punch her in the face in front of the kids. And he was also trying to take her son out of her hands while he hit her. The officers did observe bruises on her face. Her left eye was swollen and her lip was busted. She also said that she had some wrist pain from when he was trying to snatch the phone from her. She did inform the officers that they lived together. Your Honor, I believe the May 2022 battery family violence is, my Odyssey is running a little slow right now, but I believe it is with the same victim, and that is the purpose of having the cash bond. He has a battery family violence from February, it looks like, a battery in 2021 and a cruelty third, and he's got the May, Your Honor. And so because he has failed to, he continues to reoffend, and because he continues to batter the same victim, that is why the cash bond is in place, and the state's position is that it should stay the same, nothing further.
Do you have the information, Ms. Bacchus, on those other bonds that he is out on, what they were?
Give me 1 second. I can pull it up, but my Odyssey is running a little slow.
Okay. If you'll pull that up for me, I'd appreciate
Absolutely.
it. Ms. McLeod?
Yes, Your Honor. My client is 22 years old. The open cases are against the same alleged victim, Your Honor, who apparently calls the police and makes allegations that are untrue. My understanding is that this has happened many times, not only to my client, but to others, because apparently she has 2 other children, and she did the same to the fathers of these children. She is actually on the Zoom, Your Honor. I will say that she has been contacting me, trying to get me to get my client out, saying that these things were made up. And my client sits in jail. He's only 22 years old, and this just has been ongoing. And I don't know how to get him to where he can have a trial, because somebody's not speaking the truth. But behind all of this, my client is sitting in jail. His mom is also on the Zoom, Your Honor.
Okay.
Your Honor.
Yes.
So it looks like on the 21 CP 202806, which is the February charges, that bond was, it looks like a $12,000 surety bond. And the 22 CR 002814, which is the May, I believe that's a $5,000 surety. And so he was out on 12/5, and then it turned into cash on this last charge.
All right. Do you know who issued those bonds, and was there a stay away?
That I don't have. I'm on a bond screen, so I'll have to go. But I would assume so. I can't imagine that. I can't check for the felony case, but I can check on the 22 CR. So just give me 1 second.
Okay, I need to know if there was a stay away.
Okay. I'm sorry, Judge. I'm having trouble with my connection and my Odyssey. It's running very slow.
You're talking about the 220028114E case?
Yes.
They made a 5,000 good bond. There's no further contact with Alexis Johnson to stay away from 400.
Thank you.
One-time escort to return get items.
Thank you.
And that was
That's
done
me.
on May the 9th of 2022 by you.
Okay, all right, so I gave him that bond back in May. It was a good bond, and it was no further contact with Ms. Johnson. So does anybody else have anything they want to contribute to this before?
I do, Your Honor.
Yes, Ms. McLeod.
My client wants to abide by what the court says, but according to the alleged victim, they have a child together and they have to have contact. And I think she keeps initiating the contact.
All right, Ms.
She
Johnson.
is on the Zoom, Your Honor. She is actually here.
Okay, would you like to address the court, Ms. Johnson?
I've never in my life, but none of it.
I'm right here.
Raise your right hand. You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
All right, what do you want to tell me?
The incident they keep saying happened in May. We had our son in May. I didn't call the police in May. I told him he was supposed to tell his attorney that he had got a case in a different county. And when he got transferred to Fulton County, that's when the old case showed up from his other cases from the first case. Nothing in May. I never called the police, or me and him didn't have an incident in May. I had our son May 10th. There was no incident that happened in May.
I think that's when the bond was set, right?
Yeah,
So
he had got.
it would have happened before.
Incident happened on April 12th.
That's correct.
April 12th is when the incident happened. So,
He was arrested in May the 7th.
and then he was arrested May 7th, and then he got a bond from me in May. So, anything else you want to say? And let me just make this quite clear to everybody. No further contact means no contact. It means no personal contact. It means no phone contact. It means no internet contact. It means no contact whatsoever. We've got a number of cases where, Ms. Johnson, you are the complaining witness in the matter. No contact means no contact. I understand that you have a child together. You're going to have to get a third person to transfer custody of that child. I'm not going to keep Mr. Vaughn from his child, but he cannot have any contact with you. The one thing that bothers me the most is when I tell someone to do something, I give them a reasonable bond, and the condition is to stay away. Had he stayed away, he would not be in the situation that he's in right now. He would not be sitting right here, you know, regardless of whose fault it is. No contact means absolutely no contact, Mr. Vaughn.
Your Honor, my client is 22 years old. He met Ms. Johnson when he was quite young. She is much older. She's 30 or 31 years old. And I think he's in her thrall, and this just keeps happening.
Your Honor,
Your Honor, that
there's no relevance to
any of this.
that.
Well, you all know I listen, so I'm going to listen, and I understand Ms. McLeod is doing what she needs to do for her client, and I'm going to listen to her argument. But yeah, you all understand how I feel about this. So.
First originated on September.
All right, does he have a place to stay, Ms. McLeod?
He does, Your Honor. His mom, he can stay with his mom. She's actually on the Zoom.
Ma'am, would you like to address the court?
You have to unmute yourself. I think she wants to address the court, but she is muted, Your Honor.
Hello,
Yes, what's your name, ma'am?
Tiffany Smith.
And who are you, Ms. Smith, to Ja'Cory Bond?
I'm his mother.
Can you raise your right hand?
Can we see her, please? Your
I'm
Honor?
trying to figure out, hold on.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Ms. Smith. What would you like to tell the court?
He does have somewhere to stay. He lives with me. So, with the no contact, that's what's very confusing because in May, she had the baby. So before May, 2 or 3 months before May, they asked can she stay with us because she had nowhere to go and she was about to deliver the baby. So therefore she was at our house. Ja'Cory still lives at our house. Now she is supposed to be here also. So like, he want to be able to see his son and stuff. So it's like, what are we supposed to do? Because at the end of the day, if she goes, then there's a good chance that he's not going to be able to see his son until they figure it out because there's no contact. So that's what I think why is the contact they're making arrangements and stuff like that for the son to be seen. The baby's 5 months old and he's also lives with us.
All right, so therein lies the problem. They're not having, you heard what I just said, they have absolutely no contact. So,
okay.
All right, so unless you can work that out, you want him to be sitting right here where he is now?
Absolutely not.
Absolutely not. But that's whatever you all did, that's what put him here.
Right.
Okay.
But see, I didn't even know about all the no contact. So you got to remember, this is my first time being on the call. When they have it any other time, I've been at work or I didn't know about it. So I didn't even know. I'm hearing all the stuff now about the different contacts and this kind of stuff. I have no idea about all the other cases where you saying different stuff was said. This is my first time ever being able, Ms. McLeod, send me the link so that I could start being a part of the court. Me or my husband, we've never been, involved in this at all, the Zoom or anything.
Okay, well, now that you have been involved, Ms. Smith, now you know, okay? So is Ms. Johnson still living with you?
Yes.
Okay, so that's a problem.
Right.
All right, so. Ms. McLeod.
Yes, Your Honor.
I'm going to give them the opportunity to work that problem out. And I'm going to leave the bond where it is at the present time. If they work that problem out, you can bring him back here for a bond modification. But I'm not modifying the bond. And now that everybody knows he's in violation, he's in violation of the previous bond that I set. He's probably in violation of another bond for felony court. So, if they get that worked out to where she doesn't live there or he lives someplace else or whatever, then come back and I'm happy to hear from everybody. But as to now, this bond that's set is going to stay in place. All right.
Thank you, Your Honor. Your Honor, that concludes my business before the court today. May I be excused?
Yes. Am I going to see you this afternoon, Ms. McLeod?
You will, Your Honor.
Okay, I'll see you this afternoon.
Thank you, Your Honor.
Who do we have next?
Position number 2, Mr. Barker, Fort South.
And this is a negotiated plea?
Yes, sir.
Mr. McLean, are you with us? Mr. McLean.
Microphone is muted.
There we go. Unmuted.
Okay. All right. So this is Mr. Barker, negotiated plea.
It is, yeah, Mr. Barker is a negotiated plea.
Good morning, Mr. Barker. I'm Judge Eric Morrow. This is the state all-purpose calendar that was conducted by video. Do you agree to have your case heard by video?
No, sir, this is my first time.
Okay, but we're doing this over the video, so is that okay with you?
Oh, yes, sir. Yes, sir, definitely.
All right, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Okay, you can put your hand down. Thank you. Ms. Bacchus?
Yes, Your Honor, the state's offer is 12 months, 30 days to serve, credit for time served 15 days, balance probated in anti-theft class, 20 hours of community service, and he can go non-reporting after conditions are completed.
Does he have any other thefts in his history?
Yes, Your Honor, he does. He has a 2011 theft by shoplifting conviction, a 2013, a 2015 NOLO theft by shoplifting, a 2017 theft by shoplifting NOLO, a 2019 theft by shoplifting NOLO, a theft by taking in 2005, one in 2006 as well.
All
Those
right.
are arrests, the 2005 and 2006, all the rest of convictions.
Mr. McClay?
Yes, Your Honor, the defense would stipulate to the facts and venue, et cetera, and would ask the court to accept the negotiated plea.
Mr. Barker, it's my understanding that in case 20 CR 000052A, you wish to plead guilty to theft by shoplifting. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Mr. Barker, I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it's going to go to a non-reporting status, okay?
Yes, sir. I appreciate that.
All right, you're welcome. Have a good luck to you.
Can I say one thing, Judge? I want to understand. I ain't trying to hold nobody up. I was trying to understand why I didn't never know about this. I'm on 18-year felony probation right now. I've been out on the street for 6 months. Nobody never knowed I had warrants.
Okay, well, I'm sorry about that, Mr. Barker. It might have something to do. This is a 2019 case, and we did have the pandemic around that time. So, okay, good luck to you, sir.
Now, position number 22, Mr. Jermaine Moore.
And that's going to be a negotiated plea, Mr. White?
That's correct, Judge.
Good morning, Mr. Moore. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good morning, Your Honor.
Good morning. Can you raise your right hand for me, Mr. Moore? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Ms. Tortorella?
Yes, Your Honor, the offer is 12 months, served 30 days, credit for time served 12 days, balance probated, an anti-theft class, and MHET. And no restitution required. Items were recovered. Nothing further from the state.
You want him to serve additional time on this?
We're asking for 30 days, Your Honor. This is supposed to be a felony, but we're treating it as a misdemeanor.
He's been in custody since the 7th, so it would be 30.
So is this going to be a non-negotiated plea?
No, the credit date is incorrect.
Okay, yeah. Because
Okay.
if he's been since the 7th, I think we're surpassed the 30 with the 2-for-1, correct?
That's my argument.
So tell me what he's getting credit for.
You have 3 more days to serve.
Hold on, Your Honor. Let me look at the jail screen.
He's been in jail for 12 days. He will have 3 more days.
Okay, so we'll convert it to 24 days.
Okay. Thank you. So 24 days credit for time served, 12 days.
He was bound over from Union City, so he's been in custody since the 7th. He's just
I'm sorry, Ms. Tortorella. What were the other conditions, if any?
Okay, yes, Your Honor. So it's a balance probated, anti-theft class, and MHET.
Okay. All right, Mr. White?
Judge, we just asked that you waive his probation fees and terminate the probation once he completes all his requirements.
Any objection to termination?
No objection, Your Honor.
Mr. Moore, it's my understanding that in case 22 CR 006917C, you wish to plead guilty to theft by shoplifting, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Moore. I'm going to waive the fees for you while you're on probation and help you get and stay on your feet. And when you complete the terms, it will terminate, okay?
Yes, sir.
All right, good luck to you, Mr. Moore.
Thank you.
Next,
Who do
we
we
have
have next?
25 and 26, Mr. Paul.
I need to speak with the state about this case, Judge, if possible.
Okay. Is that Ms. Tortorella?
Yes, Your Honor.
25 and 26.
So can we just go to the, put them to the back of the calendar? Your Honor?
Okay, yeah, that's fine. So,
Well, I'm the back of the calendar.
He's gonna be to the back of the calendar, Mr. Tom. He's gonna be the last one, Mr. Tom.
Fair enough.
Okay.
Well, we work it out. That's cool.
Next, we have Mr. Robert Wheeler, position number 39.
Do we need a breakout room with the state, or you want to call? How do we want to handle that?
so who's representing Mr. Wheeler?
Are we speaking of number 39, Mr. Wheeler?
Yes.
Yes, I'll represent him, Your Honor. That's a not guilty in a bond request.
Is this your case, Ms. Tortorella?
Yes, Your Honor.
Okay,
He's
so,
already been
all
arraigned
right.
on an SAP on September the 27th. And it was set for jury trial. From understanding, it's supposed to be a bond hearing situation.
Okay. Good morning, Mr. Wheeler. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Raise your right hand for me. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, Mr. Wheeler. You've been charged in case 19 CR 000451D with simple battery family violence. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do.
How do you plead, Mr. Wheeler? Guilty or not guilty?
Not guilty.
We record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Ms. Lewis, what were you telling me about this?
I was saying that he was already arraigned on his case September the 27th on the SAP counter. The case was returned back to the judge for a jail jury. The case is back on for a bond hearing reason. That's the reason why it's back on the counter.
Okay, do I have the bond?
This was a bond forfeiture case to start with. So he bond forfeiture back on June the 3rd of 2019 in front of Judge Judge Airline. And they asked for a cash bond.
Mr. McLean?
So this is a old bond, it's a bond forfeiture case.
Your Honor, while there was a problem before, Mr. Wheeler's situation is now that he can get good mail and can tell us a good mailing address and will not miss court, considering the age of the case and the number of counts. We would ask the court to consider a signature bond. Mr. Wheeler, do you have good mail delivery now?
Yes, sir.
What is it? Where is it?
954 Decatur Street, Atlanta, Georgia, 30317.
Okay, and what is that?
It's a concrete factory where I reside.
Okay.
8,000 foot building.
So that was the first bond, but that's not the Judge Airline. Somebody filed a motion to reduce the bond amount, reduce the motion. I was in front of the judge.
Mr. McLean, this is already before Judge Edline on a motion to set aside the bond, so I'm going to let her, as I do in these bond forfeiture cases, let her decide whether she wants to modify this bond that she said or not, okay?
Okay, I'll look on Odyssey. Is there already a date set, or should I remind an attorney in that division?
There's not a date
There's not
set.
no, there's no real nice eye on here, so you're gonna have to set a date.
I'll remind somebody. Thank you.
All right, thank you. Good luck to you, Mr. Willis.
It's Sarah Armstrong is your colleague that's on this case.
It's Miss Armstrong's case, Mr. McLean.
Next, we have position number 34, Mr. Mario Taylor.
Okay.
Good morning.
All right. Good morning, Mr. Taylor. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Good morning, Your Honor. Yes, sir.
Good morning. Can you raise your right hand for me? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. My understanding, this is a plea.
That's correct, Judge.
Okay.
Got him.
Ms. Tortorella.
Yes, Your Honor. State's offer is for count one, loitering and prowling, 12 months, served 31 days, credit for time served, 31 days, balance probated, 50 hours of community service, and to stay away from the incident location, which is the Family Dollar, 2178 Campbellton Road Southwest in Atlanta. And the state will be null processing the remaining charges. Nothing further.
What position are you on?
This is position 34. Mr. White.
Judge, we just asked you to accept the plea as negotiated, waive his probation fees and allow his probation to terminate once he completes his requirements.
Any objection to termination?
No, Your Honor, no objection.
And which count is he pleading guilty to?
Count one, Judge.
That's the loitering and prowling?
That's correct.
Okay, and the other two are being null processed, or one? Yes, the other two are being null.
Yes.
Okay, Mr. Taylor, it's my understanding that in case 21 CR 004034E, you wish to plead guilty to loitering and prowling, is that correct?
Yes, sir. They said with the time served as well, Your Honor.
That's correct. He's getting time served. Yes, sir.
Yes, sir, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, sir, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury.
Yes, sir, Your Honor.
Has anyone forced you or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Taylor. I am going to waive the fees for you while you're on probation, and as soon as you complete, you're welcome. And as soon as you complete the terms, it's going to terminate, okay?
Thank you, Your Honor.
You understand you can't go back to that Family Dollar, okay?
Absolutely. It burned down.
Okay. Oh, it burned down.
Lord have mercy.
All right. Good luck to you, Mr. Taylor.
Next, Your Honor, we have position number 19, Nicholas Lucier. Nope. He can hear you. He's supposed to be going pro se, Your Honor.
Okay. Let's see. Good morning, Mr. Lucia. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir. Mr. Moore, how you doing this morning?
I'm doing fine. I hope you are as well, sir. Look, you have a right to remain silent. Anything you say can be used against you. You also have a right to have an attorney present to represent you today. We have provided you with the assistance of a public defender to represent you, but it's my understanding that you don't wish to utilize their services this morning?
Correct, sir.
Okay, and you wish to proceed without the advice of counsel on this?
We've spoken previously, but yes, sir, we'll continue pro se.
Okay, and you've been charged in case 22 CR 006851C with criminal trespass. How do you wish to plead to that?
Well, sir, we have a plea deal on the table from the state, which we'd like to discuss.
Okay, so it's my understanding, who's the solicitor on this? Ms. Tortorella, Ms. Bacchus,
I believe that's ASG Backus, Your Honor.
Backus? Okay,
She's logging back on.
My apologies, Your Honor, bad connection.
okay. Are you with me, Ms. Backus?
I am with you.
All right, so it is, from what I have down, the offer was 12 months to serve, 14 days, credit for time served, 14 days, balance suspended, and stay away from somewhere. Is that right?
Stay away from 1589 Peachtree Street. That is correct.
And what is that location?
It's the synagogue, sir.
Okay. All right, so Mr. Lucier, is that your understanding of what was offered to you?
That's my understanding. We'd like to discuss it with the state if that's possible, sir.
Okay, do you want to discuss it right now? What's your issue, Mr. Backus? I'm sorry, Mr. Lucier.
We're amenable to the 14 days time served in exchange for a nolo contendere.
He wants a no-lo, Ms. Backus.
That's fine. As long as there's a stay away, the state is okay with the no-lo.
Thank you, Mr. Walker. All right, so, Mr. Lucier, you're amenable to a no-lo. Anything, any qualms?
14 days time served, nolo contendere, correct?
Say it again?
14 days time served, nolo contendere, correct?
And the stay away, yes.
Yes, sir. Understood. Wonderful.
All right, so that's what you want to do today?
And will be released today, correct? Time served.
You will be released as soon as the jail can process you out.
Yes, sir. Thank you.
Okay, has he already completed the paperwork or not?
I'm assuming that's a no.
We're waiting on.
No, Your Honor. I did visit him and had a discussion, but he is pro se and there was no paperwork.
Okay, can we get him some paperwork?
I can deliver some paperwork physically to him in the jail this afternoon. Because he's pro se, I won't be signing it for him.
Can we email it to Officer Norris or Deputy
I
Norris?
knew you were gonna say that, Walker. I knew you were gonna say that.
I knew you would be glad to assist us.
Thank you, Mr. Walker.
Thank you.
All right, so can we get Norris some paperwork for Mr. Lucier, please? So I'm gonna have you fill that paperwork out, then I'll come back to you, sir, okay?
Thank you, sir.
All right, so let me see, who's gonna get him the paperwork?
Mr. Walker? Mr. Walker?
It's Miss Box's case, so she'll get it over. Thank you.
That'll be nice for your assistance, sir.
I'll try my best.
Ms. Backus, are you with us? Can you get that done for us?
What am I sending?
The plea paperwork to the jail. So
Sure.
that Lucier can fill it out so that we can take his plea.
Sure.
All
I sure
right.
will, Your Honor.
All right, so we'll get back to you as soon as you complete that paperwork, Mr. Lucier, okay?
Thank you, Mr. Moore. Have a wonderful day.
Okay, well, you're gonna see me again, so.
Yes, sir.
Next, y'all, we have position number 20, Mr. Luster.
That's going to be a negotiated plea. Earlier, it was announced to be announced, and he has made his decision on that.
What
Okay.
position is this, Your Honor?
Position 20? Is that your case, Ms. Tortorella?
Yes, Your Honor.
Okay. Good morning, Mr. Luster. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, good morning.
Good morning. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you. Ms. Tortorella?
Yes, Your Honor. The state's offer is 12 months, serve 18 days, credit for time served, 18 days, balance suspended, and no contact with the victim, Alaquande Thompson. And the first name is spelled ALAQUON as in Nancy, D as in dog, E. And Thompson is traditional spelling. Nothing further.
Mr. McLean?
Your Honor, he asked the court to accept that negotiated plea.
Mr. Lester, it's my understanding in case 22 CR 006782C, you wish to plead guilty to simple battery, is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Lester. Good luck to you, sir.
You too.
Mr. Lester, I'll sign your name by your express permission.
Okay.
Thank you.
What does that mean exactly?
That I'm signing your name as if you were signing it yourself because you want me to.
Okay.
Okay, who do we have next?
Your Honor, that's pretty much it I have here in courtroom two. I have, Mr. Paul. I guess he's waiting for Tom and the DA to talk.
Okay. So we need to put you all into a breakout room. And
you can go to 4 North.
Okay. So who needs to go into the breakout room, Mr. White?
Just ASG Tortorella and myself.
Okay, so if we can put them in a breakout room so they can discuss.
Okay, Judge.
And who do we have at 4 North?
He's for Tom White, so this is Mr. Reed.
Okay, so we'll have to wait just a moment until Mr. White comes back from the breakout room. All right, so let me know when Mr. Lucier completes that paperwork and we can get his case done. Otherwise, I guess we'll have to be in recess until Mr. White comes back because you
I do add-on number 1, is she at South Phoenix?
Norris, are you there? I have a number of people that we haven't taken care of.
Once I get finished here, I will have to go to 3 South, and that is position number, Mr. Franklin. I don't know the position number, Gene Franklin.
Okay, so we also, besides Franklin, we have position 7, Travis Clark. Do we know anything about Mr. Clark?
Your Honor, Mr. Clark several times, including yesterday, was not available to be visited according to the per the jail staff.
Okay, so we're gonna reset Mr. Clark until when?
Let's try one more week. I've had discussions with people in my office about asking the sheriff to let us into the zone so that we can, talk to him through the door because
okay, so we'll reset that to September 1st then, next week.
Very good.
We also have position number 9, Daryl Davis.
Same thing, same situation. Travis Clark, Daryl Davis, and we were also not able to see Mr. Is it Jean, Gene?
What about position 11, Mr. Edwards?
His first name starts with an O. Yes, same situation, Your Honor. He has been said by the jail staff to be unavailable.
Okay, so
because there are 3 or 4 people in this category, we've been discussing. We just got to see him in the zone. We've just got to figure out a way to talk to him.
And what about position 24, Mr. Mott?
We would ask to reset that 1 week, Your Honor. Considering what the offer is, there won't be any harm to him. And 1 week would be a great reset.
Okay, so September 1st for 24, Mr. Mott. What about position 25, Mr. Paul? Rick Paul?
That's who we're waiting for, Your Honor. That's the one I have here.
Okay, so we're waiting on that one.
Yes.
Position 27, Isaac Pope. You know anything about Mr. Pope?
It's not even on the pull sheet.
He's on the pull sheet.
It is. Oh, shoot.
And so we're gonna find out about Mr. Pope.
Give me 1 second, Your Honor.
What's that?
Give me 1 second.
Okay,
It said that Mr. Pope did not appear in the announcement from Tom. I don't know what that means. I don't know if he didn't want to talk to him.
okay.
So I just didn't bring
What
it.
number is Pope?
27.
Right, I see that did not appear. So I imagine that means he did not appear in the visitation booth, I'm guessing.
All right, I'll talk to Mr. White about that when he comes back. What about position 30, Derek Reed?
This is Reed now.
Oh, that's Reed there, okay. 32 and 33, Corey Shepherd.
He's out, 33. 32 and 33 has been released.
Yeah, he's been released.
32 and 33, Mr. Shepherd's released. All right. What about 36, Carlos Vasquez Chavez?
Your Honor, 6 and 36 are the same person. They just switched the hyphenated last part around. And the announcement is.
He said there's still, his position 6.
Okay, well, I've got that 6 and that he was reset already to September 1st, right?
That's what I got, Your Honor.
Okay, all right. Okay, so I think that that's everyone we need to deal with. Where are we, Mr. White?
Judge, if I could now speak with Mr. Paul, I think we can get this wrapped up one way or the other in just a couple of minutes.
Okay, you're fine. So we'll have you call courtroom 2.
Tom, call that same number.
2392?
That's correct.
Okay, gotcha.
Did Mr. McLean say that we need Franklin, Gene Franklin, or do we need him on 3 South?
I was not able to visit him yesterday.
Please check the number and dial again.
I think there was something about what unit he was in was a problem, so I'd be glad to see him in breakout now if he's available.
No, I have to look at the 3 South. What number do you dial? I was just asking about what position number is he?
Position 18, is that Franklin Green?
Okay, thank you.
Okay, so he's not at Grady anymore.
That was the Grady person, right? Another person was somewhere else, but I was told he was at Grady.
Okay.
Okay, I didn't know. Okay, thank you.
So we don't need him today, right? So we'll reset him until next week also, I guess. September 1st.
Who's that?
Right. We'll figure out some way to communicate with him at Grady now that we're aware of him.
Your Honor, I did just send over the plea paperwork, hopefully to the right person. I sent it to Norris Alton. Is that correct? To get to Nicholas Lucier, who am I sending it to?
Hey, can you refrain saying the first names of the officers, please?
My
Please take out the last
apologies.
names.
My apologies.
Thank you.
No problem.
So Mr. Gene Franklin's reset to next week,
Which one?
position 18.
Yes.
That's gonna be a big calendar. And I gotta work it.
I sent you an email about this, the persons
Yeah, and
to
I've been,
contact.
and I've been communicating with them while we've sat here in court.
Okay.
And I showed him the email that I sent over to the jail. I copied him on it. I showed
Your Honor, when the court has a minute, I am here with Ms. Kira Strong. We're on the 11 a.m. inquiry calendar. I just wanted to let you know that we are present.
Hi, Ms. Bronstein. Good to see you. Tell me again,
The DB case.
the DB case?
Oh, it is Ms. Kiera Strong, and let me pull up the case number. 21 CR 006786G.
Is Ms. Strong with us?
Yes, she has logged in.
Okay, Mr. Walker, who is covering this, this DV case? Is that you, Ms. Tortorella?
Yes, Your Honor.
It's my understanding, and you won't correct me if I'm wrong, I've been told that there was no bench warrant to set aside because one wasn't issued by the,
Okay.
by the division.
Your Honor, I didn't see any such warrant in the system either.
Okay, it's just when I looked, I saw that the case was dormant. So if there was no bench warrant, then that's fine. Now it looks like it's still active, but I didn't know about this case. I had a separate case with Ms. Strong that she had shown up to all of her court dates for. And we had a trial calendar yesterday. So when I looked that up, I saw this other closed case. And when I clicked on it, it said dormant due to not coming to court. So if there's no warrant and now it's active, then we're fine with her just continuing with the case. Now we know about it and we're representing her.
And you have, and the court has the updated information, if there is updated information for her.
I have a more updated email address for her. I can.
You want to put that in the chat, Ms. Lewis?
Yes.
She can put in the chat or she can email it to me and I'll let the litigation manager know for Judge Mayer.
Here, I will put it in the chat right now. I just got it this week. I just put the email address in there.
All right, so if, with that, is there anything further, Ms. Bronstein?
No, Your Honor.
Okay, good to see you.
And
Thank
Your
you,
Honor,
Judge.
the state is requesting if Ms. Kiera Strong can turn on her camera. All right, thank you, Your Honor. The state will not be requesting a bench warrant. Thank you.
Okay, all right, have a good day, Ms. Strong.
Thank you.
Thank you.
You're welcome.
Bye,
All right,
Judge.
take care. All right, so we'll remain in recess until someone's ready. You ready, Mr. Wright?
That's a loaded question, Judge. Yes, we're going to ask for a jail jury at this point.
What position?
Okay, tell me what,
I'm sorry, it's 25 and 26, Mr.
okay.
Paul.
25 and 26, and he needs to be arraigned on these?
I believe so, Judge. I'm not certain. The incident date is 5/4 and 5/18, so it's possible he's been arraigned.
Yes, he does.
I'm being told he does, so let me go ahead and arraign him on these. Mr. Paul, can you hear me?
Yes, Your Honor.
Good morning again. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you. Mr. Paul, you have been charged in case 22 CR 006785F with criminal trespass, and in case 22 CR 006788F with loitering and prowling. Each of these charges carries a maximum penalty of 12 months in jail and/or $1,000 fine. Do you wait for a reading of the accusation, Mr.
Yes,
White?
Judge.
How do you
Yes.
plead, Mr. Paul, guilty or not guilty? It's my understanding that you were going to plead not guilty to these charges today. Is that correct?
Yeah, I thought something else was gonna be worked out that was feasible, but no, I'm not.
Okay. So you're just going to have to tell me a yes or no. You pleaded not guilty. Is that correct?
Yes, Your Honor.
Okay, thank you, Mr. Paul. We'll record your not guilty pleas. Your case will be returned to the division judge, and you'll get notification of your next hearing date, sir. Good luck to you.
Why isn't my time for DeKalb County not being registered?
I don't have an answer for you for that, Mr. Paul. You'll talk to Mr. White, and maybe you all can come to some type of resolution.
And Your Honor, I mean, if I brought that up with the state, and I explained to my client that is not there, they do not have to give him credit for the time that he did in another jurisdiction on a different charge. They're not considering it at this point. So,
Okay. All right, Mr. Paul, good luck to you, sir.
All right.
We still have, we want to go to 4 North now.
Yes, position 30, Reed.
What are we doing with Mr. Reed?
this will be not guilty, jail jury, Judge.
Okay. Mr. Reed, good morning. I'm Judge Eric Morrow. This is the state. Good morning. This is a state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Mr. Reed, can you hear me?
I hear you.
You can? Can you hear me?
Nah, I can.
Okay, we're doing this by video. Is that okay with you?
Yes, sir.
All right, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes,
okay, you can put your hand down. Mr. Reed, you've been charged in case 22 CR 006791G with battery and giving false information to a law enforcement officer. Each of these charges carries a maximum penalty of 12 months in jail and or $1,000 fine. Do you wait for a reading of the accusation, Mr. White?
Yes, Your Honor.
How do you plead, Mr. Reed? Guilty or not guilty? It's my understanding that you're going to enter a not guilty plea today. Is that correct, Mr. Reed?
Mr. Reed?
Not guilty.
Okay. We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, Mr. Reed.
Hey, man, I got to sit in here. No, look, I rather plead guilty because it's not making sense to me. I rather plead.
Well, Mr. Reed, it's my understanding that regardless that the state is asking for additional time on this matter, so you would not get out of custody. Mr. White, if you want me to put this, if you want to talk to him further and put this on next week's SAP calendar, I'm happy to do that also.
That's a possibility, Judge. Just give me 1 second, please.
Okay.
My understanding is this case isn't holding him, so it doesn't. I'm double check. It is, but he does have other holds. Should we reset it for a week for him to make
Okay.
a,
All right, I'm happy to. So we'll reset. We're gonna revisit you next Tuesday, okay, Mr. Reed. So you'll see me back next Tuesday, and if you all can work something out, we'll move forward then, okay?
Yes, sir.
All right. See you next Tuesday.
Can I interject for a second, too?
Yes.
Mr. Reed has made a bond already. October 17 with Jet Bond Company. Only thing is, he already made bonds on his Jeep. And only thing that's holding him is the felony, fugitive, justice, fingerprint thing in foreign hold.
Okay, well, maybe they can resolve that by next week.
Yeah, he already made bond on his case.
Okay, do we have the plea paperwork for Mr. Lucier?
He wants to go over the plea paperwork with you.
Okay, can you,
He doesn't want to give it to me
Until it's reviewed, sir.
okay, so I'm gonna have to, I'm happy to go over the paperwork with you, Mr. Lucier.
Thank you, sir.
All right. You have a copy? Thank you.
Yeah, my mother, my brother, my dad.
I'm sorry. I'm gonna talk to that.
Okay, you're fine.
I have the appropriate. He would have to sign, but I don't know if they gave him a copy of that.
Okay, so, Mr. Lucier, let's see, you're still under oath in this matter. First question is, do you plead it's gonna be NOLO to the charges which the accusation accuses you of? And
May I go straight to the issue, sir?
oh, sure. I thought you wanted to go over the entire paper with me. What's your issue?
My issue would be, first of all, does the court accept the plea deal of 14 days served, time served, nolo contendere?
Yes, you all have negotiated that, and that's going to be the sentence of the court if you go forward with a plea today.
Okay, so I took the liberty to amend the state's deal, criminal trespass, where it says 12 months to serve. I crossed that out, initialed and dated.
Well, that's just semantics. It's 12 months to serve, 14 days. Credit for time.
I'm sorry, go ahead.
Credit for time served, 14 days, and the balance suspended. So the balance of that probation is suspended. So that's what that means.
So it's a suspended sentence.
Yes.
So that's not the deal that we had in place. It's just a 14 days time served, nolo contendere. And the issue is settled today.
Okay.
That's what was on the record and agreed to. I don't know why she's laughing.
No, that's the wording, Mr. Lucier. That's not, that is the sentence.
Having gone over it with Mr. McLean, he explained it as literally his words were a loaded gun being held over my head. So if we could amend the paperwork to 14 days time served, nolo contendere, I'd be much more comfortable.
Well, the issue is that they're suspending the probation, but part of the probation is that you have a stay away in place, right?
From the address listed, yes, sir.
Right, from that synagogue. So they're suspending the sentence, but you are not to go back to that synagogue for the time for those 12 months. okay? If you do go back to that synagogue, then you'll be in violation of the deal that you're making today.
So it's a protective order on the address listed for 12 months. It's not a suspended sentence or anything like that.
Well, you're getting 12 months, but the probation's being suspended. Mr. White, do you have any? I don't know. Do you have a way that you explain it to your clients, Mr. White?
Judge, technically, he does have a point. There is a difference between a straight time served sentence and a balanced suspended sentence. A balanced suspended sentence, it's in effect the same amount of time that he would spend in jail, but because the sentence is suspended, if he were to go back to the synagogue, for example, during that 12 months of his sentence,
it would be an automatic 11 months, 14 days.
Wouldn't be an automatic, but the state would potentially have the ability to bring the case back before a judge and say it was suspended upon this condition. He did not keep the condition. So
that's correct, and that's the state's offer. So either.
So the agreement that was made on the record was 14 days time served, nolo contendere, pursuant upon not returning to the address listed.
Which is a suspended sentence, sir.
Your Honor,
Just went over that.
the state's offer was 12 months, 14 days to serve, credit for time served, 14 days, balance suspended, and stay away from the incident location. The 12 months was stated on the record.
And that's why I stated specifically 14 days, time served, nolo contendere, with a release today, pursuant upon not returning to the listed address.
Okay.
Your Honor, the offer remains the same.
So the state is not accepting your amendment, Mr. Lucier. So their offer was what Ms. Bacchus had stated. So what would you like to do today?
Well, sir, we were on the record.
Yes, and we were on the record, and she did state that on the record, and it's also on the paperwork that we have. So,
well, no, sir, they're reneging on the verbal contract that we made in your court.
they are not reneging because what Ms. Bacchus just said is what was said previously. So either you accept that or you don't. What would you like to do today, Mr. Lucy?
Forgive me, sir. Just one more time, I would like to state that the verbal agreement is precisely what I stated. And it was agreed to by the state and it was recognized by you.
Okay. That is your interpretation of what was.
No, sir, it's not an interpretation. That's precisely what was said. Excuse me.
Okay, so there is not a deal. So as
So to
such,
continue, sir, has anyone told you that you will receive a lesser sentence for entering this plea? I would state yes, correct? Is that what I put on the form?
it would be a no. You have not received. No one has said that you're gonna receive a lesser sentence.
Is that not my understanding of the state's deal? That's a lesser sentence than the 12 months, $1,000 or $5,000 for misdemeanor?
This is why you shouldn't represent yourself.
No, this is why the paperwork should be discussed in open court. Because you're asking me to commit perjury on the record in writing.
At this point, Your Honor, I don't think that we should go forward with this plea. I don't believe that the defendant is, how can I say this, is comprehending what's going on.
All right, Mr. Walker, I have a service dog that's being held, so I will go ahead with the agreement. Thank you for your time today.
The state has some concerns that the defendant is not comprehending what's going on during his plea, which is obviously, which is problematic.
No, sir, that's not correct at all. I accept the terms. I'll fill out the paperwork because I have a service dog that's being held and I need to tend to him. Thank you.
I'll see that.
I don't have any issue with his competence, Mr. Walker. I believe that he wants to be as clear as possible. And as counsel has already said, it would behoove him to have a lawyer representing him. But he chooses not to. So
okay.
Complete the paperwork. Mr. Lucier, I will look it over and I'll get back with you.
Thank you, Mr. Moore. Should I wait here?
Yeah.
Is the paperwork complete?
Yes, sir.
Okay, well, give it to the deputy and have him get it to me. And we
Your
will.
Honor, I gotta print him out another, plea paperwork. He got a lot of scribble scrabble on.
He's
there.
gonna print a copy. I amended the copy that I have, so he's gonna print out a fresh one.
Okay,
Thank you
all
for your
right,
time.
so when you
God
complete
bless.
that paperwork, get back with me. Let's see. Do we have anyone else that we can take? Who are we waiting for?
Ms. Robin Cooper, at the South Annex, is she available?
I believe, did we, I may be missing something. Did we do Rose Lee Cooper yet? I don't think so. Add-on
Okay.
number 1.
I think that the South, is she at the South Annex?
She is, and although MHET was listed, when I spoke to her, she's lucid, she's fine, she doesn't appear to have any mental health problems, although there may be a diagnosis in the past.
Okay, I'm being told that's an error. Can we have someone call the South Annex? Mr. Jordan, Miss Grace, to see if,
What called the South Annex judge?
in regards to position number 1, Ms. Cooper, she was supposed to be on the pull list today.
Okay, will do.
What's that?
Will do, Judge.
Okay, thank you. And are we waiting for position 27, Hope?
Excuse me, Judge, she made bond.
Okay, thank you.
You're welcome.
And Mr. White is position 27, Ms. Pope, is that your?
It is, Mr. Pope didn't appear at the window yesterday when I attempted to interview him.
Okay. So I guess we're gonna reset that till next week.
If they can get him, I don't know, a lot of times the reason they don't show up is because of mental health reasons. I don't know if that's the case here, but he does have an offer that would have him released.
Right.
So if it's, I understand if you want to if we could reset him, if we have to reset him, is it possible to get him on the Thursday calendar?
That's fine with me. If we can get him today, I'm happy to let you talk to him today, if courtroom 2 can get him.
This has been a good calendar so far.
What's going, Norris, do we know what's going on with position 27?
Who's position 27?
Is Pope, Isaac Pope?
Hey, Tom, didn't you did not see or did not come out, or what was it?
I did. Exactly.
That's the only reason we didn't pick him up.
Oh.
You didn't really specify what you wanted us to do.
Oh, I'm sorry. If they're not needed, I would tell you that, but I just assumed that we would speak with him here. So, I mean, if we want to reset him to Thursday.
Is it too much to get him
No,
today?
and he's on 2-0. Can somebody go get Pope out of 2-0?
Okay, so he's got a plea deal that's gonna put him out today, so if we can get him.
Yeah.
Let me double check. Give me 2 minutes, to double check, make sure there's nothing else holding him.
Yeah, I don't want to block my blessings now. And I'm gonna send this plea paperwork over to Ms. Backus.
Okay.
Okay.
Ms. Bacchus, are you with me?
And Judge, that is the only thing he has holding him, so.
Okay, so let's see if we can deal with him today. I don't want him sitting in jail if he doesn't have to. And when you get that paperwork, would you send it to Ms. Lewis, please, Ms. Bacchus?
What paperwork is that?
Uh,
Oh, the plea paperwork that's coming back?
Yes.
Okay.
Ms. Bacchus, have you gotten that paperwork?
I just got it. I'm sending it to Miss Grace right now.
Miss Grace, Miss Lewis.
Ms.
Oh,
Lewis.
Miss Lewis, wrong person. Sorry. Wait.
Lewis, I'm in the house.
Let's get it together, Ms. Backus.
Excuse me? What's happening? Okay, can somebody put, what's the first name for Miss Lewis?
Katrina, I'm putting in the chat. Katrina
Thank you. I got it. I'm sending it now.
Okay, very good. I've received the paperwork. Ms. Bacchus, you ready to proceed?
I am ready, Your Honor.
Okay. Whenever you're ready.
Sorry, 1 second. Sorry, scroll back down, Your Honor. The state's offer again on this was 12 months to serve, 12 months, 14 days to serve, credit for time served, 14 days, balance suspended, and stay away from the synagogue located at 1589 Peachtree Street. And the state was amenable to the no-low plea.
All right. Mr. Lucia, anything further? You're on mute, courtroom two.
Just conclude with scripture, sir. Treat younger men as brothers, older women as mothers, and younger women as sisters with absolute purity. 1 Timothy chapter 5. Thank you for your time today.
Okay. Mr. Lucia, it's my understanding that in case 22 CR 006851C, you wish to plead guilty to criminal trespass. Is that correct?
Nolo contendere.
You wish to plead nolo to criminal trespass. Is that correct?
Nolo contendere. Yes, sir. That's correct.
Yes. Are you under the influence of any drugs or alcohol this morning?
No, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading nolo to it, you're giving up your right to a trial by jury?
Yes, sir.
Do you understand that if you're currently on probation, that your probation could be revoked because of this plea?
If we are, yes, sir, I understand.
Do you understand that if you are not a United States citizen, your immigration status could be affected by this plea?
Yes, sir.
Do you offer this nolo plea freely and voluntarily with a full understanding of the charge against you?
Yes, sir.
All right, I will accept the nolo plea as negotiated. Good luck to you, Mr. Lucia.
Thank you, sir. You as well, Mr. Moore.
Thank you.
Your Honor, whenever you're ready, I have Mr. Pope here.
All right, one second. Okay.
Ms. Cooper still is in here.
Oh, okay. And this is,
Can I call to speak with Mr. Pope?
yeah. Can we get Mr. Pope to a phone?
Okay.
All right. So,
McLean, the 2392 number.
who is representing Cooper?
Hello?
Mr. Pope?
Yes.
Mr. Pope, my name is Tom White. I
Mr. White, we can hear you.
Yesterday, but I don't know what
Mr.
happened
White,
somehow or another.
Mr. White.
They
we can
didn't
hear
come
you.
pull you or whatever, but you're being held on a theft by deception.
Can we,
charge.
Hey, fine, we can hear you.
Alyssa, mute.
Oh.
Hey, tell him that you need to mute his thing.
Alyssa, she can mute.
Got it. Thank you. Very good.
all right.
Yep. Yep.
Okay, Judge, we've. Oh, I'm sorry.
Yes, Mr. White.
Judge, Mr. Pope would like to accept the state's offer.
Okay. Let's see. Good morning, Mr. Pope. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Can we get on mute courtroom too?
I said yes.
Okay, thank you. Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you, Mr. Pope. Ms. Tortorella?
Yes, Your Honor. The state's offering 12 months served 19 days, credit for time served 19 days, balance probated, 40 hours of community service, an anti-theft class, and no contact with the victim, Connor Osborne. The last name is Osborne. The first is Connor, and nothing further.
Any objection to termination? Once the terms are complete?
No objection.
Okay, Mr. White?
Judge, we'd ask if you waive the fees, probation fees, Wally.
Okay, anything else?
Nothing further from the defense, Judge.
All right, Mr. Pope, it's my understanding that in case 18 CR 004036Y, you wish to plead guilty to theft by deception. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, I do.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Pope. I will waive the probation fees for you while you're on probation. And once you complete the terms, that anti-theft class, then the probation will terminate, okay?
Okay.
All right, good luck to you, Mr. Pope.
Thank you.
Thank you, Your Honor.
Okay, so I have been informed that we're trying to get the South Annex back on the line for position number 1. Add-on position 1, Rosalie Cooper, because Ms. Cooper has not been released. Does that complete everything in courtroom 2 today?
That's all we have, Judge.
Okay, all right, so I will see you all this afternoon. And we'll wait for, and as we're waiting for the South Annex to come back on, Ms. Lewis, can we go over the calendar? Okay. And who's representing Ms. Cooper? Is that your case, Mr. McLean?
Yes, Your Honor.
And you're gonna need some time to talk with her?
No, Your Honor.
Okay, all right.
All right, can everybody hear me? I'm gonna start with the add-on calendar. Position number 1 is we're waiting for the South Annex to come on. Position number 2, defendant was arraigned. The case is reset for trial per the notice. I'm on the regular calendar now. Position number 1, the defendant was released. Case is reset for the notice. Position number 2 was a plea. Position number 3 was a plea. Position number 4 is reset for the SAP November the 1st. Position number 5 is reset for the notice. Defendant was released. Position number 6 is SAP, reset for SAP November the 1st, along with the companion case. Position number 7 is reset for the SAP November the 1st. Position number 8, defendant was arraigned. The case is reset for trial for the notice. Position number 9, is reset for SAP November the 1st. Position number 10, defendant was released. Case is reset for the notice. Position number 11 is reset for SAP November the 1st. Position number 12 was a plea. Position number 13, defendant was arraigned, case is reset back to the original judge for bond modification. We can set for trial further notice. Position 14 and 15, defendant was released, case is reset further notice. Position 16, defendant was arraigned, case is reset for trial further notice. Position 17 was a plea. Position number 18 to be set for the SAP November 1st. Position number 19 was a no-go plea. Position number 20 was a plea. Position 21 to be set for SAP for November the 8th. Position number 22 was a plea. Position 23 was transferred to Superior Court. Position number 24 is reset for SAP November the 1st. Position number 25 and 26, defendant was arraigned. The case is reset for trial further notice. Position number 27 was a plea. Position 28, defendant was released. The case is reset further notice. Position 29, defendant was arraigned, reset for trial further notice. Position number 30 is coming back on the November 1st SAP calendar. Position-
September. Right?
November the 1st? Or 30? I thought y'all were coming
Right.
back next week.
Right. Oh, okay. No, you're right. You're right. I'm sorry. Go ahead.
Yeah. Position number 31 was a no-go plea. Position 32 and 33, defendant was released. The case is reset further notice. Position number 34 was a plea. Position 35, defendant was arraigned. The case is reset further notice. For trial, the bond was amended to $1,000 SOB through the jail. Position number 36, reset for SAP November 1st, along with the companion case. Position number 37, receive a transfer order to Superior Court, already signed. Position number 38, defendant was arraigned, case is set for trial, amended bond, all his charges were amended, bond amended to SOB through the jail. Position number 39, is back to the original judges for a trial calendar further notice. Any questions, any concerns, any repeats? Also, I need all of the bond orders, modified bond orders, plea paperwork, any other orders, please send to Katrina Lewis in a timely manner.
Okay. Is this Ms. Cooper that we have?
Yes.
And what are we gonna do with Ms. Cooper today, Mr. McLean?
That's a negotiated plea, Your Honor.
All right. Good morning, Ms. Cooper. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, ma'am. Ms. Bacchus?
Yes, Your Honor. The state's offer is 12 months, served 56 days, credit for time served 56 days, balance probated, MHET, and stay away from the incident location, which is St. Joseph's Hospital at 5665 Peachtree, Dunwoody Road, unless obviously there's an emergency or they're being treated.
Mr. McLean?
Your Honor, Ms. Cooper asked that the court accept her negotiated plea with the state. We do stipulate as to venue, factual pattern.
All right, Ms. Cooper, it's my understanding that in case 22 CR 005900A that you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. I am going to waive the probation fees for you, Ms. Cooper, while you're on probation to help you get and stay on your feet. And when you complete the terms of the probation, it will go to a non-reporting status, okay?
Yes, sir.
All right, good luck to you, Ms. Cooper.
Thank you, Your Honor.
Thank you, Your Honor.
You're
So
welcome.
what happens from here? Do I go home?
As soon as you can get processed out of the jail, if you don't have anything holding you, Ms. Cooper, then you'll be released.
Oh, okay, thank you.
Okay, you're welcome. All right, thank you. Thanks, everyone. I appreciate it. We will see you next Tuesday.
Thank
you, Judge.
you.
All right.
Okay.
Bye-bye.
Thank you, Your Honor.